I have watched law change this way before, not through legislation debated in chambers and signed on camera, through court orders filed at 4:47 p.m. on a Friday, through regulatory clarifications buried in Federal Register notices, through state attorney general opinions that reinterpret statutes without amending a single word. The changes arrive quietly. By the time anyone notices, they are already being enforced. 12 distinct shifts have restructured how firearm regulations operate in the United States over the past 36 months. Not one of them came through comprehensive legislation passed by Congress. Not one generated sustained media coverage. But collectively, they have rewritten the practical boundaries of Second Amendment rights for over 140 million gun owners across 43 states. And most of those owners do not yet understand what changed. The first shift concerns sensitive places. After Bruin struck down New York's discretionary concealed carry licensing system, 7 states responded by dramatically expanding the list of locations where firearms are prohibited, even for licensed carriers. New York redefined sensitive places to include Times Square, all public parks, all public transportation, every place of worship unless explicitly permitted by the property owner, every government building, every healthcare facility, bars and restaurants that serve alcohol, all theaters, all stadiums, and any location hosting a public gathering or a special event. California followed with similar restrictions. New Jersey created a default rule that carry is prohibited everywhere except where explicitly allowed. Hawaii imposed comparable limitations. These laws do not ban concealed carry. They ban it in so many places that the right becomes theoretical rather than functional. A permit holder in Manhattan can legally carry a firearm, but cannot do so on the subway, in Central Park, near a government building, in a restaurant that serves wine, in a church, or anywhere a permitted street fair is occurring. The practical result is that legal concealed carry in New York City is nearly impossible despite the Supreme Court's ruling that the state must issue permits. Multiple federal courts have issued preliminary injunctions against portions of these sensitive place laws, but those injunctions apply only in specific districts or only to named plaintiffs. The laws remain in effect for most people in most locations, and the legal battles are ongoing with no clear timeline for final resolution. The second shift involves private property defaults. Several states have inverted the presumption about whether concealed carry is allowed on private property. Traditionally, private property owners who wanted to prohibit firearms would post signage indicating that guns were not permitted. The default was permission, unless the owner affirmatively restricted it. New Jersey and Hawaii reversed that default. Now, carry on, private property is prohibited unless the owner has posted explicit permission. This places the burden on property owners to authorize rather than restrict. And in practice, most commercial properties simply avoid making any statement, which means carry is prohibited. The third shift concerns ghost guns and parts definitions. The Bureau of Alcohol, Tobacco, Firearms, and Explosives issued a final rule in 2022 redefining what constitutes a firearm under federal law. Previously, only completed frames and receivers qualified as regulated firearms requiring serial numbers and background checks to purchase. The new rule expanded the definition to include parts kits, unfinished frames that can be readily converted to functioning firearms, and any combination of parts that together constitute a functional firearm, even if disassembled. This definitional expansion brought approximately 4 million previously unregulated items under federal firearms law overnight. The practical effect is that selling an unfinished 80% lower receiver, previously legal without any licensing or record keeping, now requires a federal firearms license, serial number engraving, and compliance with all regulations governing firearm sales. Home manufacturing of firearms remains legal, but acquiring the components now involves the same background check process as purchasing a completed firearm. The fourth shift tightened serialization and home manufacturing rules. The same ATF rule that expanded parts definitions also imposed requirements on anyone manufacturing a firearm at home for personal use. Individuals must now apply to ATF for a serial number before completing a homemade firearm and must engrave that number on the frame or receiver. Failure to do so transforms what was previously lawful home manufacturing into possession of an illegal, unserialized firearm. Enforcement has begun. ATF has initiated prosecutions in at least 14 cases involving individuals who possessed homemade firearms without the newly required serial numbers. The fifth shift involves pistol braces. ATF issued a rule in January 2023 reclassifying firearms equipped with stabilizing braces as short-barreled rifles, subject to National Firearms Act regulation. The rule gave owners of an estimated 40 million braced pistols a choice. Register the firearm as a short-barreled rifle, pay a $200 tax, and submit to NFA restrictions. Remove the brace and return the firearm to pistol configuration. Permanently attach the brace so it cannot be shouldered, or turn in the firearm. Millions complied, millions did not. The compliance deadline passed in May 2023, which means that millions of Americans who legally owned braced pistols in December 2022 are now technically in possession of unregistered short-barreled rifles, a federal felony carrying up to 10 years in prison. Legal challenges to the pistol brace rule remain active. Multiple district courts have issued injunctions, but those injunctions apply only to plaintiffs who are members of specific organizations that filed suit. The Fifth Circuit blocked enforcement against members of the Firearms Policy Coalition and the Second Amendment Foundation. But for gun owners who are not members of those organizations and do not live in the Fifth Circuit, the rule remains in effect. The legal status of a braced pistol depends on where you live and which organizations you belong to, creating a patchwork of enforcement that varies by jurisdiction. The sixth shift concerns magazine capacity bans and the growing inconsistency between states. As discussed earlier, 11 states restrict magazine capacity to between 10 and 15 rounds. But the specific definitions of what counts as a high-capacity magazine vary. California bans magazines over 10 rounds with no exceptions. Colorado allows 15 rounds, but only for magazines manufactured before July 2013. Vermont allows 15 rounds, but defines large capacity magazines differently for different types of firearms. Crossing state lines with a standard 17-round Glock magazine means complying with different rules depending on your route. You're legal in Pennsylvania, illegal in New Jersey, legal again if you cross into Delaware, illegal if you enter Maryland. The same physical object shifts between legal and felonious based on geography. The seventh shift involves red flag laws and the rate at which they are being used. 21 states now have extreme risk protection order statutes. These laws allow family members, law enforcement, or in some states, employers and school officials to petition courts for temporary firearm removal based on allegations of dangerousness. The number of orders issued has increased dramatically. California issued approximately 3,000 orders in 2020. That number rose to over 8,000 in 2023. Washington State issued 412 orders in 2020 and over 1,000 in 2024. The trend is consistent across jurisdictions. The laws are being used more frequently, and the threshold for issuance appears to be lowering as courts become more familiar with the process. Many of these orders are issued ex parte, meaning without the gun owner being present or even notified until after the order is in effect. The first notice many people receive is when law enforcement arrives to confiscate their firearms. Hearings to contest the orders typically occur weeks later. During that period, the firearms are held by law enforcement. Even if the order is ultimately not extended, the process of retrieving confiscated firearms can take months and requires navigating bureaucratic procedures that vary by jurisdiction. The eighth shift concerns domestic violence and protection orders. Federal law has long prohibited individuals subject to domestic violence restraining orders from possessing firearms. But the definition of what qualifies as a prohibiting order has expanded through case law and regulatory interpretation. Orders that previously did not trigger firearm prohibitions now do. The Supreme Court's decision in United States versus Rahimi in 2024 upheld firearm dispossession for individuals under restraining orders, but lower courts have since applied that reasoning to temporary orders, emergency orders, and even orders issued in family court proceedings that do not involve findings of violence or threats. The ninth shift involves the expansion of prohibited person categories. Federal law lists categories of people who cannot possess firearms: convicted felons, fugitives, illegal drug users, individuals committed to mental institutions, individuals dishonorably discharged from the military, individuals who have renounced their citizenship, and individuals subject to certain restraining orders. But state laws have added categories. Illinois prohibits anyone who has been a patient in a mental health facility within the past 5 years. California prohibits anyone convicted of certain misdemeanors. New York prohibits anyone who has been involuntarily committed for any reason, including temporary emergency holds that lasted less than 72 hours. The result is that someone who is not a prohibited person under federal law may be prohibited under state law, and vice versa. The 10th shift involves the replacement of unlicensed carry prosecutions with wrong place carry prosecutions. After Bruin, states that previously prosecuted people for carrying without a license shifted enforcement focus. Now, the prosecution is not for carrying without permission. It is for carrying in a prohibited location. The criminal penalties are often identical, but the legal theory has changed. Before Bruin, you were arrested for not having a permit. After Bruin, you are arrested for carrying near a government building, on public transportation, in a park, or in any of the dozens of newly designated sensitive places. The practical effect is the same. Carrying a firearm in public results in arrest and prosecution. But the constitutional challenge is different because the state is no longer defending discretionary licensing. It is defending location-based restrictions. The 11th shift concerns assault weapon definitions and how they vary by state. 7 states ban assault weapons, but they define the term differently. New York's definition focuses on specific named models and certain features. California uses a different feature-based test. Connecticut bans weapons by name and also prohibits any firearm that accepts a detachable magazine and has one additional prohibited feature. Maryland's law is different still. The result is that a firearm configuration legal in one state is illegal in another, and the determining factor is not functionality but the specific statutory language each state adopted. A rifle with a fixed magazine is legal in New York but illegal in California if it has certain other features. A rifle with a pistol grip is illegal in Connecticut but legal in Pennsylvania. Manufacturers produce state-compliant variants, but the complexity of compliance across multiple jurisdictions creates constant legal risk for owners who travel. The 12th shift involves licensed dealers and private sales. Several states have closed what they call the private sale loophole by requiring that all firearm transfers, even between private individuals, be processed through a licensed dealer with a background check. Colorado, Washington, Oregon, Nevada, New Mexico, and Vermont all enacted universal background check laws between 2019 and 2024. These laws make it illegal to transfer a firearm to another person, even temporarily, without going through a dealer. Loaning a firearm to a friend for a weekend hunting trip technically violates the law in these states unless the transfer is processed through an FFL. Giving a firearm as a gift to a family member requires a background check. The laws include exceptions for immediate family in some cases, but the exceptions vary by state and are narrowly defined. Enforcement of these private transfer laws is difficult because there is no way to track transfers that occur without dealer involvement. But when violations are discovered, usually during investigations of other crimes, they added additional charges. And they create legal traps for gun owners who do not understand that a transfer that was legal for 2 centuries is now a crime in their state. These 12 shifts did not arrive through a single comprehensive gun control bill. They arrived through court rulings, administrative rules, state legislation passed in response to federal court decisions, regulatory reinterpretations, and enforcement policy changes. Most gun owners are not tracking Federal Register notices or state attorney general opinions. They do not read court decisions or monitor ATF enforcement guidance updates. They own firearms. They comply with the laws they understand to exist, and they assume that if something was legal last year, it remains legal this year. That assumption is no longer safe. The legal framework governing firearms has become fragmented, inconsistent, and rapidly shifting. What is legal depends on where you are, what organizations you belong to, which court district you fall under, and whether you are subject to any of the expanding categories of prohibition. The right remains constitutionally protected. The regulations surrounding it have multiplied to the point where compliance requires constant attention to legal developments across multiple jurisdictions and regulatory agencies. I have watched this pattern before. Not the elimination of a right, but the construction of a regulatory architecture so complex that exercising the right becomes a legal minefield. The Second Amendment has not been repealed. It has been surrounded, and for millions of Americans, the difference between those two outcomes is becoming difficult to distinguish.